Lawyers for death row inmate Robert Roberson are facing new challenges as they try to get a new trial.
Roberson was convicted of murdering his 2-year-old daughter, Nikki, in 2003. Evidence at the time blamed shaken baby syndrome for Nikki's death. In the years since, the syndrome has been discredited by experts, and last month, Roberson was granted another stay of execution while both sides head back to court. Fox 4's Amelia Jones in studio tonight with where the case goes from here. Amelia.
Heather, Steve, the back and forth between the state's attorney general's office and Robert Roberson's defense team comes down to timing and procedure. The judge overseeing the case wants more information from both sides before deciding whether to hold an evidentiary hearing. After avoiding another execution last month, Robert Roberson faces yet another roadblock in his pursuit for a new trial. His defense attorney is asking the Anderson County court judge to schedule a status conference so both the defense and state can discuss the next steps, including an evidentiary hearing with live testimony. The Texas Attorney General's office disagrees. In response, the AG's office said the defense is, quote, putting the cart before the horse, and cited that state law requires other steps in the process before holding any hearings.
If the science doesn't support their conviction, then certainly they would want it expedited because that would be their path to freedom. And then if the science does support their conviction, the state would seem to want it expedited as well.
Russell Wilson is a former Dallas County prosecutor not involved in the case. Roberson's murder conviction of his 2-year-old daughter, Nikki, hinged partially on the diagnosis of shaken baby syndrome, which more recent science has debunked in other cases, including one in Texas involving Andrew Rourke. Wilson worked in the district attorney's office when Rourke's case was reviewed.
So here, the same questions would probably be asked in this case. Can the doctors stand by their testimony at the time? What's changed and why and how? And then are there studies that show that what their testimony at the time was wrong?
The Anderson County judge hasn't granted or denied Roberson defense attorney's request for an evidentiary hearing. Instead, he asked both sides for more information, including an estimate on the number of witnesses, the anticipated length of time needed for testimony, and how long each side would need to prepare for the hearing. Wilson says ultimately it's the judge who has the power to set the schedule.
Ordinarily, a court's going to take control of a matter that's remanded to it, and scheduling is normally within the discretion of the trial court.
In her response, Roberson's defense attorney asked the judge to consider scheduling the hearing in March 2026 or at the very earliest January 2026 so she can work on compiling experts to testify. The state asked the judge to be allotted the same amount of time as the defense to present its case and adequate time to find their own experts to testify. Steve, Heather.